Imagine you are an environmental activist standing in a crowd. Above you, an automated police camera locks onto your face. Read the exam prompt. The police scan a crowd, lock onto a specific protester, retain their biometric facial data, and subsequently restrict their access to future public gatherings. The scenario presents two distinct legal triggers. First, retaining your biometric data immediately engages Article 8, your right to respect for private and family life. Second, banning you from future gatherings directly targets Article 11, your freedom of peaceful assembly. It is tempting to approach this scenario through the lens of morality or sweeping civil liberties. You must resist that instinct. To solve this problem, you need to apply a rigid, mechanical framework. This flowchart is the standard procedural roadmap for testing the breach of a qualified right. Top marks in administrative law exams do not come from impassioned conclusions. They are awarded for meticulously passing the facts through each discrete stage of this procedural engine. Look at the first gate, determining if a convention right is actually engaged. Article 8 covers a vast spectrum of human experience. It protects physical bodily integrity, personal autonomy, your correspondence, and your home. In the case of S. and Marper, the European Court of Human Rights ruled that the state retaining fingerprints and DNA from innocent people constitutes a clear interference with private life. The right is firmly engaged. Now consider Article 9, freedom of thought, conscience, and religion. This right operates through two distinct limbs, internal belief and the external manifestation of that belief. The state cannot regulate what you think. Your internal belief is an absolute right. Only the second limb, the external manifestation, like wearing specific clothing or engaging in public worship, is a qualified right subject to state interference. Examiner's tip: distinguish between these two limbs immediately. Treating the entirety of Article 9 as a qualified right is a critical structural error that will cost you marks. Once a right is engaged, the burden shifts to the state. They must first prove their interference is prescribed by law, meaning it has a clear, accessible statutory basis. Next, the state must show the action pursues a legitimate aim. The European Convention on Human Rights explicitly defines these aims. They include the interests of national security, the protection of health, and public safety. If the state clears those two hurdles, they face the final and most complex stage of the engine, the proportionality test. The definitive framework for modern proportionality analysis in the UK was established by the Supreme Court in the 2013 Bank-Malott case. Bank-Malott requires the court to ask four specific questions. First, is the objective sufficiently important to justify limiting a fundamental right? Second, is the measure rationally connected to that objective? Third, could a less intrusive measure have been used? And finally, has a fair balance been struck between the rights of the individual and the interests of the community? This final fair balance question introduces the margin of appreciation. The strictness of the court's review fluctuates depending on the exact nature of the right being restricted and the specific aim the state is trying to achieve. Deportation scenarios frequently appear on exams because they force a direct collision between the state's mandate to maintain public safety and an individual's Article 8 right to family life. The leading case here is Uner v. the Netherlands. Uner moved to the Netherlands at age 12, eventually having a partner and children there. Years later, he was convicted of manslaughter and assault, leading the state to issue a 10-year exclusion order. The legal issue is highly specific. Does deporting an individual, thereby severing his daily relationship with his partner and children, disproportionately violate Article 8? To solve this, the European Court of Human Rights established a 7-factor test requiring a mechanical evaluation of elements like the length of residence, the severity of the crime, and the best interests of the children. Applying this test, the court placed extreme weight on the severity of Uner's manslaughter conviction and his documented history of violent offenses. Against this, they weighed his family ties. Uner had only lived with his partner for a short period, and his children were young enough to easily adapt to a new environment. Because the threat to public safety heavily outweighed the limited disruption to his family life, the state struck a fair balance. The deportation was proportionate and lawful. Examiner's tip: writing that deportation disrupts family life will fail. You must actively list and weigh the specific unner factors against the facts of your scenario to secure high marks. This balancing process becomes even more nuanced when evaluating Article 9 manifestations in the workplace. To see how the margin of appreciation shifts, look at two cases with nearly identical physical facts. First, Aweda. A British Airways employee was suspended because she refused to hide a small, discreet silver cross. The airline argued their interference pursued the legitimate aim of projecting a specific corporate brand image. The court ruled that protecting a corporate brand was not sufficiently important to limit Aweda's fundamental right to manifest her religion. The balance failed. Article 9 was breached. Now look at Chaplin. Here, an NHS nurse was moved to a non-nursing post because she refused to remove a virtually identical cross necklace. In this instance, the hospital's legitimate aim was protecting clinical health and safety, specifically preventing injuries while handling patients on a ward. The court granted hospital managers a wide margin of appreciation, determining they were better positioned than a judge to assess clinical risk. The interference was deemed necessary and proportionate. The physical act, banning a necklace, was exactly the same. The legal outcome inverted entirely because clinical safety carried vastly more weight in the proportionality test than corporate branding. Let's return to the opening problem question, the environmental activist targeted by police facial recognition technology. We run these facts strictly through the chronological steps of the Judicial Engine. Step 1. Engagement. The European Court of Human Rights established in Glukin v. Russia that the use of facial recognition technology on peaceful protesters is highly intrusive. Because of that extreme level of intrusion, capturing and retaining the image undeniably engages Article 8. Step 2. The state must prove this surveillance was prescribed by law. To test this, we apply the ruling from Bridges v. Chief Constable South Wales, a case directly concerning police trials of facial recognition. In Bridges, the Court of Appeal found that the relevant police policies and codes of practice failed to set sufficient limits on officer discretion. The legal framework was too broad and imprecise. Because the police lacked a sufficiently precise legal framework, the action fails at Step 2. The interference is inherently unlawful, and the grueling 4-part Bankmalat proportionality test is never even reached. Administrative law rewards cold, structural logic. By finding a fundamental statutory flaw early in the engine, you save crucial exam time and demonstrate a true mastery of the legal mechanics.